As you are entering the seminar, I will start with a brief disclaimer. CLE presentations are intended for educational purposes only and do not replace professional judgment. Statements of fact, opinions expressed are those of the presenters individually, and unless expressly stated to the contrary, are not the opinion of the Florida Bar or its committees. The Florida Bar does not endorse or approve and assumes no responsibility for the content, accuracy, or completeness of the information presented. Any feedback should be provided to the event organizer. Good afternoon, everyone, and welcome to the Florida Registered Paralegal Enrichment Committee's January 30th, 2026 free CLE webinar. There was a change in the programming today due to unforeseen circumstances, so the presentation today will be in AI and ethics. During the webinar, if you have a question for the presenter, please post it in the question and answer section at the bottom of the screen. The chat feature is disabled. Some of the questions will be answered by the presenter at the end of the presentation. Due to time constraints, there may not be time to answer all questions. At the end of the webinar, I will provide everyone with the course number, which you will use to self-report your credits in the member portal. We are not taking attendance. I will now turn it over to the FRP Enrichment Committee's CLE Subcommittee member, Bonita Smith.
Thank you. The Florida Registered Paralegal Enrichment Committee invites all of our participants today to visit the FRP Corner on the Florida Bar website, as well as our various social media platforms. It is there you will find helpful tips and announcements of upcoming events in our monthly webinars. Jonathan Grabb is the director of the Ethics and Advertising Department, Ethics Counsel for the Florida Bar, where he has served since November 2021. Prior to that, Jonathan served the department for 8 years as an assistant ethics counsel. Jonathan has fielded more than 20,000 calls on the Ethics Hotline, reviewed thousands of lawyer advertisements, and issued dozens of staff opinions. Jonathan is also the staff liaison to the Florida Bar's Board Review Committee on Professional Ethics, Professional Ethics Committee, and Standing Committee on Advertising. Jonathan's work as ethics counsel has included a variety of CLE presentations and bar news articles, included the March 13, 2023 article, Lawyers in AI, How Lawyers' Use of Artificial Intelligence Could Implicate the Rules of Professional Conduct. Jonathan?
Thank you, and I appreciate the introduction. Thank you, everyone who's here in attendance. And sorry, we already got a comment that indicates it's on mute. Hopefully, you can all hear me just fine.
Yes, we can hear you. I took care of it. No one's on mute.
All right, thank you. Just confirming. All right, so yes, you've already gotten the introduction. I am Jonathan Grabb. I work with the Florida Bar in the Ethics and Advertising Department. We run the Ethics Hotline, as well as respond to written ethics inquiries and review lawyer advertisements. So that is really the function of what we do here. We're not on the disciplinary side. So we get to be the nice guys, basically. A couple of caveats before we get started here. First, and these are that I always give in my AI presentations, I'm not a computer scientist. I'm not a computer ethicist. What I am is the Ethics Counsel for the Florida Bar. I know the rules regulating the Florida Bar, and in particular, the rules of professional conduct, and that's really what I can talk about. That's where my knowledge lies. So I'm not really going to be as familiar in the with the intimate details of how a software program operates or the hardware that it runs on. But yes, I have some experience here with AI programs and really how they've impacted the professional obligations that we have as lawyers. Two other quick points. One, I apologize for being a little informal. As noted at the start of the presentation, there were some sudden changes in the presentation, so I hope you don't mind that I'm a little bit informally dressed. The other is if you are someone who sat in on the Volusia County Paralegal Association presentation back in October, you may have already received credit for this presentation, and if that's the case, I apologize. But yes, this portion of the presentation is something that was previously created for that Volusia County Paralegal Association. So when we're talking about ethics and AI, and particularly generative AI, What really has changed in the last 3 years since generative AI became the hot topic? Yes, there have been some significant technological developments. We've gotten guidance since then, specifically from Florida, the American Bar Association, and from the courts. We've had lots of lawyers get in trouble with the courts for the improper use of generative AI. But we still have found some very promising uses for AI that while they may not replace, and certainly I would not recommend trying to use them to replace your professional judgment as a lawyer, what they can do is really supplement your practice and improve your work. And sorry, yes, if you did it, and to answer a question real quick, if you did attend the CLE in October, if you try and log this for credit, it's going to be under the same CLE course number. So no, I don't think you'll be able to get the duplicate credit. So my apologies there. Last, we have some unresolved questions, basically, that I like to address just because there are a lot of things that are still uncertain about the use of AI. And yes, we also are giving technology credit for this presentation, as well as ethics credit. So just to start off, again, what is AI? Well, it's a very generic term, artificial intelligence. It's the science and engineering of making intelligent machines, especially intelligent computer programs. It's a very broad term. And, really everything we have up to the present is what you would consider weak AI. It's trained and focused to perform specific tasks. Your calculator, it does math functions. Those sorts of programs where, again, you have potentially these programs that are very targeted at performing a specific function, whether that's word processing, creating a database or spreadsheet, whatever that may be. But it's limited by its programming. And then there's the potential for strong AI, which are programs that would equal or exceed human intelligence. In those instances, I mean, really, when you're talking about specific tasks, yes, there's a lot of programs that would exceed human intelligence. But when you're looking at strong AI, they don't have the breadth of capacity so far that, of course, the human mind would. Now, generative AI, of course, is what refers to these models that actually take the information that you ask them, a query that you put in, and then they generate statistically probable outputs when prompted. And that is something that I would absolutely highlight. It is still statistically probable outputs. It's essentially them looking at their database and saying, not what logically makes sense as an answer to this, but looking at this broad database of similar questions and similar answers. Okay, well, what words or what phrases would come next in response to this? So again, it's not really so far that it seems like these programs are actually using what we would consider logic in most instances, but rather they're taking a look at this massive database of potential similar answers and putting in something that seems to make sense from those answers that they have available, that database they have. They also, yes, may include self-learning programs, which of course then you have to be careful to make sure that they're not using your client's information to supplement their database and improve it. And unfortunately, yeah, it's generally impossible at this point for a developer of a generative AI program to know how a response is generated because all of that is done by the program itself very rapidly. And frankly, yes, we have programs and we have gotten much better in a lot of these programs, including the, commonly used programs that are not necessarily targeted to lawyers. At them citing their sources, and explaining where this information potentially came from, so you can look it up yourself. But again, how they got to that is not always clear, and why they chose those sources is not entirely clear. Now what we're looking at, and what has become especially common in the last year or so, is what they would call multimodal generative AI programs. And really what that means is you have a program that is taking potentially a prompt and creating an image or audio or video or all of the above based on that text prompt. Or in the reverse, potentially looking at an image or listening to audio, so to speak, or reviewing a video, and then actually providing a text or summary or analysis of what is displayed in that video or heard in that audio. And so that's really what a multimodal model is. Rather than going from text to text, it potentially could go from text to imaging, from imaging back to text, and et cetera. So that's really what's become more and more common these days, and potentially, yes, could lead to concerns about things like deep fakes. So if you hear the term multimodal models, that's what they're talking about. And most recently, at least for me, is agentic AI. And really, this is a fancy term that they use to describe an autonomous AI system that, at least in theory, could act independently to achieve predetermined goals. So instead of giving it specific prompts, where you're saying, hey, we have this issue with our shipping department, there's bad weather, there's a cold front that's gone across the entire United States, um, you know, what is the best shipping route? It would take that information as it's being received and say, oh, there's bad weather coming through. We may need to reroute some shipping patterns so that way we can, potentially address this before it becomes a problem. And so, yes, there you have a program that, in theory at least, again, can perform these complex tasks without constant, whoops, and typo there, without constant human oversight, and potentially independently of human input. Um, and where I got this information, you might note, is Amazon Web Services. And yes, they give some potential use cases on their website for how agentic AI may help industries. And they note an agentic AI system, however, can monitor inventory levels, track weather conditions, and anticipate shipping delays. It can proactively raise alerts and even reroute shipments to reduce downtime. So that was one use example that they gave on the website for what you might, expect of agentic AI. They also said that it might be used for computer code migration and transformation, such as updating legacy systems from an old coding language that may not be in, broad usage anymore, as well as incident response coordination potentially. So that's really what we're, talking about for agentic AI. One thing, though, that was kind of a surprising coincidence to me is if you look, at the citation here, I got this information from Amazon Web Services on October 16th, 2025. I don't know if many of you remember this, but we had about a week later, after I accessed this information, a massive outage by Amazon Web Services that, for many people, knocked out their access to basically half of the internet as it existed because so many different systems were relying on Amazon Web Services to essentially run their servers, to run their websites, and all of these different programs that were out there. And, I can't help but wonder, is this part of us outsourcing again our judgment to AI? And maybe it's not as perfect as, managing that code migration as we might hope. And, yes, it makes errors just like an actual person could. So that is something that honestly struck me as a bit of a coincidence at the time. And, we've had outages, with CrowdStrike, I believe it was, and a couple other programs more recently. And, I do, again, have to wonder, are these updates and these issues occurring in part because, we're using AI to create the code, and then we don't necessarily know where that code might have issues then and problems when we try and actually implement that new code. Again, that's just speculation on my part, so take that with a grain of salt. So here's some research tools that specifically are tailored to lawyers and for generative AI programs for research tools. So again, from Thomson Reuters, you have your CoCounsel and Westlaw Precision programs. LexisNexis, you have Lexis Plus AI. There's Vincent AI from VLEX and Harvey AI. These are some that, again, are from a bit more reputable legal research organizations. So hopefully they're going to be tailored more to the needs of us as lawyers to make sure that one, confidentiality of client information is protected. Two, that hopefully the hallucinations that have occurred in other programs are going to be less frequent and less likely. As well as three, that you've got that, potentially more advanced analysis, hopefully, specifically tailored to a legal review. Getting back to hallucinations, this is something that Sam Altman addressed first when OpenAI created ChatGPT back in November of 2022, and it became public, and AI was really, suddenly generative AI was that buzzword. He noted that, when you're talking about hallucinations, he said, quote, "There's a balance between creativity and perfect accuracy, and the model will need to learn when you want one or the other." He then went on to suggest that it may be about 2 years to, quote, "get the hallucination problem to a much, much better place," end quote. Um, well, when you're talking about, again, those legal research programs, what is an acceptable failure rate? We have courts now, and I'll be getting into this a bit more in a moment, but we're 3 years into this process, into generative AI being a common feature, and yet we're still getting false citations. Presumably, I assume that you're also getting evidence supposedly that was from a record that does not actually exist. In instances, or an inaccurate representation of the record when people are using AI to review it. And so, when the courts are looking at this and saying, we never received in our 30-year career before this moment a false citation to a case that does not exist, and now suddenly it's happening on a regular basis, is that an acceptable failure rate? Even if it's 1 out of 1,000 citations that one just happens to be fake and falsely generated? I mean, I don't know as a practitioner if I would be comfortable with that, even if it's 1 out of 1,000, maybe even if it's 1 out of 10,000, because again, my license is on the line. And if this is something that never happened in thousands and thousands of filings prior to this, well, I mean, yeah, it suggests that 1 out of 10,000 is maybe still not even acceptable in a circumstance like that. All right, so in preparation for this program, what I did do, and again, this is from back in October, so keep in mind there may be updates to the programs. I went through some questions and basically, posed them to an AI program. And you'll see in the first example here, I went through several and essentially saw what answers they would come up with and how close they were to an accurate answer and to what extent they would actually back up that answer with resources. So this is just a program that I got, on my phone, just a generative AI program that I think there's like, a $30 or $40, annual subscription for the program itself. And I posed it these questions. All right, first, I'm accused of a crime and my brother says I wasn't there. Should my lawyer have my brother as a witness? And the first answer, and this was from ChatGPT 4.0 Mini, is if your brother can provide an alibi or relevant information that supports your defense, it may be beneficial for your lawyer to consider having him as a witness. And goes on basically to explain that, yes, it could be an alibi, and I'm not going to read these out verbatim. But it does acknowledge in its response, however, whether or not to call him as a witness is a strategic decision for your lawyer, which is correct. They don't give any citation or explanation for how they reach that result, but that is correct, at least for the state of Florida. They will consider various factors such as the credibility of your brother, the specifics of your case, and how his testimony fits into your overall defense strategy. So again, that is something, again, that it's an accurate answer. How it got there, who knows? But yeah, 4-1.2 of the rules regulating the Florida bar does provide that a lawyer has to abide by their client's decisions regarding the objectives of the representation. But generally notes in the comment, for example, that as lawyers, we are responsible for those strategic, technical, and tactical decisions for how that representation, how those objectives are carried out. And so again, when something comes up and you're wondering, well, my client insists that this is the argument I should make, or my client insists that this evidence is accurate and, not false information that I'm providing to the court, you cannot outsource your judgment to the client in those circumstances. Again, you should pursue their objectives, but you as the lawyer still have to make sure you're complying with your duties of competence, candor, and, avoiding false and frivolous arguments. All right, so same question proposed to Claude. You can see here that there's a much more detailed answer that it gave, and it actually broke down some factors to consider, and ultimately noted that it's up to your lawyer to decide the best strategy. So again, Claude seemed to give that answer, and it said, again, you're going to look at the credibility of the witness, the strength of the alibi, the overall defense strategy, and again, whether or not this fits in. But again, reiterates it's your lawyer's professional judgment about whether calling your brother as a witness is the right tactical decision. And that yes, you should discuss those concerns with your lawyer, but it's ultimately your lawyer's call. All right, Grok, asking the same question again, goes through, again, a more detailed analysis and talks about alibis and credibility, defense strategy, cross-examination, that essentially maybe your brother might not be a great witness. And so even to the extent that, he could provide an alibi, it might actually be harmful to your case on cross. So again, it talks about discussing this with your lawyer, but it doesn't actually answer that fundamental question, Grok's response here, about whose decision this is. Can the client insist that you call his brother as a witness? Grok does not get into that. So you're going to get different answers depending on what AI program you ask this question, and frankly, probably depending on when and how you frame it. And part of the reason I wanted to frame this question first is that you're talking about, you're going to have clients, and I'm sure many of you already have, where they put the exact same questions that they're asking you into an AI program, and they're going to show up and they're going to say, well, that's not what Grok told me. That's not what Claude or what ChatGPT told me, and so you're going to have these basically answers from these programs that you need to be ready to respond to and address when, a client basically says, no, I don't think you're right, even though you have years of experience in this field. All right, so on to a different topic. Some ethics opinions that we have regarding generative AI. And one just proud note for us as members of the Florida Bar and, paralegals, legal practitioners here in Florida. You can see the first is Florida Bar Ethics Opinion 24-1. That was published January 19th, 2024. And as far as I can tell, is the first of its kind in the entire country. And then we have ABA formal opinion a few months later, July 29th, 2024. So what you're going to see in 24-1 was issued by the Board of Governors for the Florida Bar on January 19th again of 2024. And it was actually following an inquiry by the Florida Bar's Special Committee on AI Tools and Resources. They actually posed the original inquiry for the bar to consider. And then the opinion itself addresses, which I'll get into a bit more detail in just a moment, four primary topics: confidentiality, oversight, fees and costs, and advertising. And that's, again, in response to the inquiry that was posed for the Florida Bar to respond to those questions. And of course, this is all available on the Florida Bar's website. So first, to explain what we're really talking about when we say confidentiality. So Rule 4-1.6 in Florida is the rule regulating the Florida Bar that addresses confidentiality, and its corollary in the model rules would just be 1.6. And it notes that all information related to a client's representation is confidential. And that, yes, you may disclose information if it's reasonably necessary to serve the client's interests. Again, you may, you're not required to do so. And again, that's only if the client hasn't specifically required you not to disclose the information. So when in doubt, informed consent under sub A of 4-1.6 is the safest option. Make sure that your client specifically acknowledges and grants you that authority to disclose information, including to an AI program potentially. 4-1.6 sub E likewise provides that we have a duty as lawyers to make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the client's representation. So how does this apply again to generative AI? Well, first we go back to that question noted earlier. Is the program self-learning? Does it store those inputs or results? Even if it's not adding it to its database, does it keep a history of the inputs and results? And how do potentially the owners of this program use those results? I mean, if you're talking about a free AI program, it's quite likely that they make money by selling the information that's input into their program to, potential marketers or third parties so that they can use it to target, potential advertising. So again, if they're storing that information or the results of a query, what happens to it after that? Did you research the provider? Do they have a reputation such as, Westlaw or LexisNexis, where, they do this type of work, this type of research, historically? What kind of security measures does the provider have in place for the security of the information in their database, including, again, those inputs and the results of the queries? Are there liability waivers? And so, is there an enforceable obligation to keep the information that they are provided secure and potentially notify any people using their program of a breach or demand for production of the information that they have generated or has been input? And likewise, do you have the option potentially to maintain your own private database where instead of having that information sent off to, some process on the cloud, some third party, on, who knows where that information is stored, are you actually able to keep it in your own servers on site? In which case, yes, it's much easier to keep that secure than it would be if, this is in the hands of a third party. So the next topic that 24-1 deals with is oversight. And this is something that for a lot of you as paralegals in the audience, frankly, are probably going to be pretty familiar with. So Rule 4-5.3 addresses our responsibility as lawyers for the oversight of non-lawyer staff. And again, whoops, sorry, another typo that I'm seeing now. And while it's not directly applicable, again, to the use of generative AI, it does require that we as lawyers, take reasonable efforts to create policies assuring compliance with our obligations under the rules of professional conduct when we're, having a non-lawyer staff assist us in a project. And ultimately, it reinforces that we as lawyers are responsible for our work product. And there's two cases there that I'll get into again a little bit further on in the presentation, where the courts, they expect that of us. If you are trying to say that, this is, oh, well, this was an AI program or this was done by a legal assistant, it's not going to be something that the court's going to be very receptive to. They are going to be looking to the person who signed those pleadings, the lawyer who is appearing in front of them, for making sure that their information is accurate and complies with their ethical obligations. Now, that said, the opinion recognizes that it might not be such a bad idea to treat generative AI like a new assistant or a paralegal, because, again, or first year associate for that matter. Because if you're trusting it to do that legal research or respond, maybe draft responses to clients, communications, that sort of thing, you need to be ready to, expect that it may not always quite get to the right answer or know quite how to interpret your request. At this point, AI is just not that developed. They're not going to have the experience of a 10, 20, 30-year paralegal or legal assistant, where, yeah, they can probably handle a task pretty independently and you can trust them and just, hopefully do a brief review and make sure that it is okay. But, where they've done this hundreds or thousands of times before, and come up with, what you would expect as their work quality. We're just not there, it seems like, with AI yet. And so again, these duties that are addressed in 4-5.3 and, indirectly with generative AI, it doesn't matter if the non-lawyer is an employee or, a third-party contractor, you still have that responsibility to oversee and supervise their work. And again, there's some functions that can never be delegated to non-lawyer staff or presumably AI, like handling a deposition, negotiating, handling intake decisions, or providing legal advice. All right, next, regarding oversight is, potentially this idea of intake. Again, we have another rule, 4-1.18, that specifically addresses a lawyer's responsibilities regarding prospective clients. And, website chatbots potentially here are something that lawyers should be very careful about. The rule notes whether communications, including written, oral, or electronic communications, constitute a consultation depends on the circumstances. For example, a consultation is likely to have occurred if a lawyer specifically requests or invites the submission of information about a potential representation without clear and reasonably understandable warnings and cautionary statements that limit the lawyer's obligations, and a person provides information in response. That's pulled from the comment to Rule 4-1.18. And so essentially what it's saying is that, yeah, this lawyer-client relationship, as provided in case law there, depends on the reasonable subjective belief of the person submitting the information. If you don't make it very clear that they are talking with a chatbot and that they are not actually getting the protection of a lawyer-client relationship when they're chatting with some program, some window that pops up when someone visits your website, you may have just conflicted yourself out of a representation that you already had going. Because now this new person believes that they've received legal advice from this chatbot on your website, or that they've created an attorney-client relationship already. And now once that's created, now you have a concurrent conflict of interest with current clients under 4-1.7. And even if you withdrew under 4-1.9 sub A, you now have a former client and the same or substantially related matter. And you can't continue that representation of the existing client without the former client's informed consent. So yeah, you may have just conflicted yourself out because your your chatbot on your website is not properly screening, the conflicts before it's starting to give what may seem like legal advice or confirming in a lawyer-client relationship. Now, next, it addresses fees and costs. And, of course, excessive fees and costs are prohibited under Rule 4-1.5 sub A. You can only charge a client for the actual costs incurred under the rules, and you can't, of course, duplicate bills or falsely inflate hours. This also, we have an opinion, 07-2, that notes that you shouldn't separately charge if you're in a contingent fee case for third-party paralegal services, if that's something that normally would be covered by the lawyer's own office. So, say you're having a third party handle some legal research for you as a paralegal service, and they send you that research. You can't invoice that to a client in a contingent fee case because normally that would be a part of the function of your legal services. And then, again, to address some of the issues, if generative AI truly is increasing our efficiency and productivity, say supposedly a task that used to take you, 5 hours has been whittled down to 15 minutes thanks to generative AI. Well, I mean, yeah, that is something where you have to limit your bill to 15 minutes if that's all the time it actually took for you to perform that work. In turn, that may make you want to consider potentially using more contingent fee arrangements or flat fee arrangements in your representation of clients, so that way, again, rather than having to worry about that hourly billing and, potentially clients, when they say, well, why is your hourly rate so much higher, and trying to explain, well, we're just that much more efficient than we used to be, or than these other firms that might be charging a lower rate. Now instead you maybe want to consider a flat fee arrangement that's earned upon receipt, so that way, you aren't potentially making it very difficult to bill hours if generative AI truly makes your representation that much more efficient. Again, another topic from the opinion, lawyer advertising, same standard primarily for any lawyer advertising. If you're going to make a claim of quality or comparison to other lawyers' services, you have to make sure that you can objectively verify that. You actually have to be able to show that those claims are accurate. And then, of course, again, if you're using a website chatbot, yes, it should disclose that it is simply a chatbot, an AI program. And again, you may want to be very careful in what authority you give that chatbot, or what range you give that chatbot, to make sure, again, that it doesn't get you a conflict of interest that boots you out of an existing representation. So likewise, ABA Formal Opinion 512, it was issued about 6 months after Florida issued its opinion, 24-1. It actually has a lot of very similar discussion and makes numerous references to Florida Ethics Opinion 24-1, which again, it's something that we at the Florida Bar are very proud of. Our our opinion that was drafted by the Board of Governors was something that had an influence on the ABA and its guidance, for lawyers across the country. There is a little more discussion of competence when using artificial intelligence, and basically it does specifically note that you must disclose the use of AI if a client asks, but not necessarily in all cases where the client does not specifically ask. And of course, reiterates those duties of candor and meritorious claims, specifically again in the context of these hallucinations that we get from AI programs. Now, one thing that you're going to see that's different in ABA Formal Opinion 512, the ABA does not recognize or permit non-refundable fees that are earned on receipt, whereas Florida does under Rule 5-1.2 sub E, or 4-1.5 sub E. My apologies, 4-1.5 sub E. Basically, that means that you're not going to have that as an option as a fee arrangement under the ABA's opinion. So you're not going to see a discussion of that. We do have some brief rule updates also that have been issued. Again, these are within the last year here, or sorry, last 2 years, I should say. 2024, we had some updates from the court to really primarily in the comments to the relevant rules acknowledge that, yes, you need to be competent in your use of technology, including generative AI. You need to assure that you protect the confidentiality of your client's information, including when using generative AI. And again, that you as a partner, manager, or supervisory lawyer, yes, you have a duty to assure that all lawyers and potentially non-lawyer assistants in your law firm under 4-5.3 as well need to comply with their obligations under the rules of professional conduct. And you need to put reasonable policies in place to assure that yes, would address any technological developments, including their use of generative AI as appropriate. All right, so back to another AI question. Just simply, does my lawyer have to argue what I tell him to? Well, ChatGPT 4.0 Mini, I'm just giving its answer because, again, it's sort of brief. At least it acknowledges, no, your lawyer doesn't have to argue exactly what you tell them to. And, yes, again, you should have that discussion with your lawyer about what's in your best interests. But yeah, it notes specifically if your instructions conflict with legal ethics, the law, or a reasonable strategy for your defense, your lawyer may choose not to follow them. And so again, that really does seem to fundamentally get at these concepts that we have, and it's accurate when it comes to the ethics analysis, but it doesn't really tell you how you're going to support this argument because there's no citations that it provided in this example. All right, so now on to lawyers getting in trouble, because there's been a lot of them. Fool me once. We have first again, Mata v. Avianca. And I'm sure many of you have heard of this. This is the two lawyers in New York. They were actually jointly and severally sanctioned along with their law firm for using ChatGPT. It basically drafted a motion for them that cited authorities that did not exist or did not stand for the proposition for which they were cited. And part of this happened in Mata v. Avianca. Just to give some background, the case originally had been filed in state court, and that's where one of the two lawyers, I believe it was Schwartz and DeLuca. Schwartz was the state lawyer. He had been handling the case up to that point. He was not admitted to practice in the federal court. So rather than seeking admission to the federal court, they just assigned the case to DeLuca. And he started saying, ghostwriting the pleadings for DeLuca, at which point, neither Schwartz or DeLuca actually reviewed those pleadings to make sure that they were accurate or shepherdized, as noted in one of the comments in our Q&A section here. That, apparently they just weren't doing their job. And, DeLuca, again, filed this without reviewing it, rather than actually acknowledge the mistakes and that, potentially check those citations and confirm, okay, no, these don't exist, and seek leave to amend to refile. No, they doubled down and said that they got them from an online database and basically never actually provided the cases, which they couldn't because they didn't exist. And ultimately, it was them doubling down that in part led to the court sanctioning them and this becoming national news. And likewise, we have following that was the People versus Crable, which is about a lawyer in Colorado. who was suspended for 90 days. Again, he filed a motion using ChatGPT. And basically this, a lot of the citations, yes, were fictitious. When the court inquired about the potentially fictitious citations, he responded by saying it was an intern, which again, I'm sure for the audience here, for the paralegals who are listening in, not exactly something you want to hear from your boss that they're throwing you under the bus, instead of, admitting that they used a generative AI program. But yeah, he blamed a legal intern and, yeah, he got a suspension for 90 days from the practice of law in Colorado. Fool me twice. Well, that's clearly not the end of it. We have Park versus Kim, where the Second Circuit referred a lawyer, this is 2024, to a grievance panel for investigation and whether or not he violated Federal Rule of Civil Procedure 11. And he had cited in a reply brief 2 court decisions, one of which they were unable to locate, and essentially admitted that, yeah, they didn't exist, and she had used ChatGPT, which had suggested the false, non-existent case. Gautier versus Goodyear, and probably butchering that pronunciation, my apologies. Lawyer sanctioned for filing a response created with generative AI without checking citations. Again, admitted in the hearing and did not check that he did not check the citations until the court issued an order to show cause. And that even though opposing counsel had actually questioned it, the lawyer didn't actually do anything until that order to show cause. And he was, fined $2,000 or sanctioned $2,000 and required to take a CLE. And yet, still, again, we have problems. All right, we have In re Newsom. Lawyer was suspended from the federal court's bar for 1 year, was required to take a professionalism course. This is here in Florida. And this is the sanctions by the federal court, to be clear. And the law practice management training ordered counseling through FLA. Lawyer was counsel for a plaintiff in a breach of contract case. It was referred to the grievance committee on the federal level for investigation. And yes, they found inaccurate citations and fabricated authorities in the amended supplementary removal. When interviewed by the committee, the lawyer acknowledged that he, quote, may have used artificial intelligence to draft the filings, but was not able to check the excerpts and citations, end quote. So again, not doing his job. And guess what? That resulted in reciprocal discipline here by the Florida bar, the Florida bar versus Newsom, where now, instead of just being suspended for 1 year from the federal court, he then got a 2-year suspension from the Florida bar for using AI again to draft that legal pleading that included inaccurate citations and fabricated authorities. So you'd think after 2 years, people would start to catch on, but no, we have Arizona, Mavy versus the Commissioner of Social Security Administration, a pro hoc vice lawyer, sanctioned pursuant to Rule 11 of the Federal Rules of Civil Procedure, again, for filing and certifying an initial brief that included fake citations, numerous inaccurate quotations, and citations that did not support the propositions claimed. Here, the court was rough. Not only was that initial brief stricken, they revoked the lawyer's pro hoc vice status, removed the lawyer's counsel of record, and required the lawyer to serve or transmit a copy of that order to the lawyer's client, who was given 45 days to secure a new counsel, the 3 judges that were attributed to those false case citations, every other judge over any case in which that lawyer was counsel of record, and finally the Washington State Bar Association, as well as any other bar association of which the lawyer was a member. So, I mean, frankly, that had to be painful. I mean, that sounds humiliating to not only have to tell your client, to then send letters to these judges that were attributed the fake cases, notify every other judge that you're practicing in front of and your bar association. I mean, yeah, they're getting tired of it. You can clearly see this. And yet, again, the court, a little bit more about Mavy, I should say. In finding the sanctions proportionate, the court explained that this is, again, not a single fabricated case. Not that that would be okay either, as the court noted. It's still, potentially, egregious just for a single fabrication. And they note, indeed, other courts have imposed Rule 11 sanctions in such an instance, And this court is not minimizing the use of a single fake case. But, clearly, yeah, when an entire pleading or brief is going to be the majority of false or citations are false, yeah, the courts are not going to tolerate it anymore. This is something that we as lawyers should know. And frankly, you as non-lawyer staff really need to be careful and make sure that your practitioners that you're working with understand these issues. And finally, yet again, we have just, from August 2025, the clerk of court versus Rangel here in Florida. There was a pro bono lawyer in an appellate case who was referred to the Florida bar, again, for an answer brief that included non-existent case citations and false quotes. And the lawyer admitted, and he was working, again, pro bono, so he's not getting paid for this, that he would have easily found the mistakes, quote, had he attempted the review of the authority provided by, quote, an independently contracted paralegal service, end quote. So again, trying to throw non-lawyers under the bus. In fairness, the lawyer did specifically request, because it was his mistake, that any sanctions be applied to him, not his client. Even so, and even though he was acting pro bono, the court referred the lawyer to the Florida bar for the delays created and the need for amended briefing. Yeah, even though he's working pro bono, that does not obviate your requirements of candor, competence. Again, these fundamental duties we have as lawyers. Yes, the court acknowledged not only did he not take that effort before he filed, but again, he didn't do anything to withdraw the brief or request leave to file an amended brief until the court literally ordered him to respond to these problems. So you can't just sit on your hands. And, yes, it seems like most of these issues involve lawyers trying to cover up for the fact that they made a mistake rather than actually, acknowledge the mistake. But, again, the courts at this point, they've seen enough of it. If it happens, they're likely going to bring the hammer down. They're not going to be very patient with lawyers who are not being proactive and doing their job to review these citations. All right, so again, just to toss in another Q&AI question, a lawyer visited my hospital after I had an accident. Is that okay? And here's one where maybe the answer from ChatGPT 4.0 Mini is not so great, saying, yes, it is generally permissible for a lawyer to visit you in the hospital after you've had an accident, especially if they are offering legal services related to your situation. And they do acknowledge solicitation laws, but no, the answer is you should not be soliciting clients in a hospital. And yes, there are potentially solicitation laws, but I mean, yes, it's going to get you in trouble with your solicitation prohibition in Rule 4-7.18. So here's one instance where ChatGPT's answer, frankly, just wrong, or certainly at the very least misleading. And again, these are things that potentially, I tried to phrase these questions in a way that an average person might. So that's something that you want to be very careful about, because these hopefully are going to prepare you a little bit more for when you run into clients who are doing the same thing. So one other thing that I found helpful that actually is a potential use case for generative AI, less so by lawyers, but frankly, I mean, there's no reason why it wouldn't also apply to the lawyers who are preparing arguments in this case. So this is, some of you may have seen this. This was from 2024. Judge Newsom in the 11th Circuit basically went through a discussion and an opinion of basically potential uses for generative AI and large language models in particular, about how, again, they might inform the interpretive analysis, particularly when determining the ordinary meaning of language. And so he goes through a discussion of, potentially some of the pros and the cons of, AI and generative AI and large language models again in this question. And the question fundamentally in that case was, is an in-ground trampoline with a retaining wall and a decorative wooden cap considered landscaping? As mundane a question as that may be, yeah, it's one that he thought maybe these large language models could help with. And, yeah, when you're talking about a massive database with billions of inputs, yeah, it's going to give you potentially a useful statistical prediction. And it can distinguish the context of words, a baseball bat for the sport versus a bat, the animal. And it can, yes, recognize that context. They're accessible, they're generally inexpensive, and, hopefully that would allow for greater access to sophisticated arguments. They're relatively transparent. I'm not sure I fully, agree with the way you describe that. Again, given that we can't really know a lot of times how they've reached the results. But he does acknowledge, well, is it the drafter of a dictionary? Is Merriam-Webster any more transparent when they, determine the definition of a term? Do they cite their sources always as clearly as, might be desired? Why would we give, Merriam-Webster a monopoly on the use of language in determining what words mean? Finally, he notes that, yeah, it could be potentially preferable to other empirical interpretive methods, because again, it's going to reflect the actual modern usage of the terms involved. Because a lot of these databases, again, are taken from, forums, chats, where people are actually using the language rather than the historical or traditional use of the language that you might find in a dictionary. Now, of course, the drawbacks of using generative AI for these analyses, there's still hallucinations. And fundamentally, it seems that that goes in part back to that statistically probable prediction for the result that they give you. That again, it's going to look at, if you insist that it give you an answer in a citation, it's going to say, well, Smith versus Jones, that seems like the name of a case. And, sure, we'll just toss some numbers in, write Southern Third, some more numbers, and then give it a date. Because that's what citations look like. And it very well may just do that, thinking that's what you're looking for, when really, no, when you're, as a legal practitioner, you need a real case that actually exists that's, providing that concept, not just something that looks like a citation. Again, the language may not be reflected truly, by the entire population, because a lot of these databases pull their information, their data input from the internet. So, yeah, there's probably also going to be underrepresented populations that just don't have as great of access to the internet, where their use of language is therefore sort of discounted by generative AI. You could also potentially manipulate AI databases and outputs. Again, I'm not sure that that's any more true than, manipulation of language in general, or sort of what people might think is more innocuous misrepresentations. And really, this last one to me is one of the scariest things potentially about AI, and that's, are we outsourcing our judgment? By giving these tasks to generative AI, have we essentially taken away our own ability to process these answers and come up with them independently? Well, one example of where generative AI has been used to great effect, and this is something you can find in the Florida Bar News. There's an article from December 26, 2023, and essentially, it talked about this program that had been used by public defender Carlos Martinez. He's a former member of the Board of Governors for the Florida Bar. And he had actually implemented this program to help his public defender's office use generative AI to manage their cases and, potentially help streamline, triage, that sort of thing. And they found a program that previously had actually had great success. Now, it wasn't quite a generative AI program, but again, it took a docketing system and essentially actually performed, at, frankly, a higher accuracy level than human inputs that were doing this work manually before. And they actually had gotten to the point in the Palm Beach County Clerk's office where they had, gotten down to 35 to 40% of all the filings actually were just done by artificial intelligence rather than manually. And again, they note that yes, they were using it to write memos and help draft pleadings. I just be careful. Of course, it's still your work product. You need to make sure that anything is said is supportable and is proper advice. And again, yeah, these are some of the potential concerns or potential uses for AI. Again, you could look at it as drafting automated client updates on cases so that way you're helping to satisfy that duty of communication. Document a record review. Again, you have a voluminous record that you're working from, and you need it reviewed, fairly quickly, so you can start your work. An AI program may be pretty good at that. Now, again, you're going to have to look at its citations where it finds that support from the record that it's citing to make sure it's accurately describing the information there. But yeah, it could actually be very helpful in finding details. Again, might help with administrative support. And one of the real things that, frankly, I think is a real good use case for AI is analyzing counter arguments or refining briefs. Essentially, you put in your brief. Again, you need to make sure that you're protecting the confidentiality of your client's information. So you may need to de-identify things, or you may need to change the facts to some degree. But essentially, you could put it into an AI program, say, where are the weaknesses in my argument? What arguments may I have missed here? And again, you're not outsourcing your judgment to AI in those situations, but you're giving AI, this opportunity as a tool to point out things that you may have missed, and that then you can actually improve your work product rather than, using delegating your judgment as a lawyer to this AI program. Last thing I'd just like to cover is there's still a lot of questions about, things like deep fakes, as well as, who owns an AI generated result. And we have basically these two cases, Thaler versus Perlmutter and Thaler versus Vidal, where essentially an individual tried to argue to the patent office and to the trademark office copyright, my apologies, and patent office, essentially that this generative AI program had created in one instance, a patent, or in the case of Thaler versus Perlmutter, had actually created this image. And here, I'll go back to that real quick. And essentially, the courts so far have come back to say that, no, generative AI is not a person or an inventor. You have to have an actual human who's identified as the author or inventor. And frankly, I think it likely would have come out differently if instead of arguing that the generative AI created these, that Mr. Thaler had created them, and just, that it was using generative AI as a tool to create these, and therefore it really was, Thaler's creation. But we don't know that yet. We don't know if that's going to be the case. The input potentially similar to taking a picture with a camera, and editing that image, if that's something that you can claim authorship for. And then on the other side of it, we have a lot of arguments that basically these generative AI programs are actually violating the intellectual property rights of individuals. And there is this case that basically is still pending, Anderson versus Stability AI et al. And where essentially, yes, there are still potentially claims pending in some of these instances. Because yes, there was a denial of the defendant's motion to dismiss under the Copyright Act, as well as Midjourney's motion to dismiss under the Lanham Act. So, yes, there are still some of those claims that may be reviewed by the court, even though some were dismissed either with prejudice or with leave to amend. Finally, keep an eye on the court's rules. Yes, most of the courts have avoided trying to actually specifically prohibit the use of generative AI. But, yes, you need to make sure that you're complying with the directions from the court, as well as, you'll want to make sure that the individual judge, if they have instructions, that you're complying with those. And of course, you have an obligation under, Federal Rule 11, or here in Florida, Rule 2.515 of the Rules of General Practice and Judicial Administration, that when you file something, you're certifying you read the document, that you believe it to the best of your knowledge, that it's good, or that there's good ground to support the document, that it's not used for delay, and that it does not contain confidential or insensitive information, or has been or in the alternative has been properly protected. So if you're filing something and you haven't even read it, of course that's a problem. But you also, yes, are saying you believe to the best of your knowledge that there's good ground to support that document. And if you falsely verify that or have, somebody do so on your behalf as a lawyer, yes, you're going to get sanctioned if there's those hallucinated citations. All right, well, that's everything I have in the PowerPoint. I looks like I have just a few minutes if there are specific questions that maybe I can look at here. And sorry, I know there's a lot to look at. Um, okay, and yeah, we have a comment from Brittany, and I appreciate this. The 11th Circuit apparently is actually requiring that you put on your pleading if you're using generative AI in your work. So thank you. That's good to know. And then if you use AI to summarize a PD document, should that be disclosed? I I mean, it depends on who you're talking about. Do you have to disclose it in Florida to the client or the court? I mean, frankly, I would err on the side, especially with the client, of disclosing. If again, if you're filing it with the court, if you don't, specifically review it yourself and make sure that that summary is accurate, well, yeah, you're relying on something else to give to make that analysis for you. And yes, you're putting yourself in peril because no, you're outsourcing your independent professional judgment. Um, the ABA opinion, it's copyrighted by the ABA, so I can't provide a copy of it, but it's should be 512 to my recollection, and I can go back to that to just verify. Um, Again, there's a lot of theory that AI could take over there's a question, have you heard of if AI may take over paralegal duties and replace an actual paralegal in the future? Um, I mean, there's a lot of, speculation that AI is going to take jobs away from just about anyone, whether it's, legal assistant, paralegal, us as lawyers, judges have talked about, potentially like, would we have at some point even generative AI making decisions on behalf of, a legal question, or as, maybe an arbitrator, essentially, an AI arbitrator. Um, again, these are all theoretical at this point. I would certainly trust an experienced paralegal more than I would a generative AI program at this point in time. But again, I think that's kind of going in the wrong direction for what I would really recommend is the use of generative AI. Rather than trying to replace staff or replace your own research, practices, again, use it to supplement those. Use it to help communicate with the clients more effectively and keep them apprised of what's going on in their case. Now, of course, before you send it to a client, you're going to want to make sure that it's accurate and, not just making stuff up about the case. But yeah, that could be a quick way to draft a message to a client just to keep them apprised and feel like, they're being heard and you're responding to them. Um, and again, to address those potential counter arguments or those blind spots that we may have as lawyers or as paralegals, to have the AI take a look at those and potentially, help us find and identify those blind spots. So doing better work, not just replacing the work that we are doing. Um, See if there's any other questions I can answer real quick in the last minute that we have. Yeah, it just in response to one of the early questions, how many participants have actually encountered hallucinated cases in their filed pleadings? I mean, I can't speak for the audience that we have here in today's presentation, but again, when I have spoken with judges and practitioners in who are appearing in litigation, I mean, I'm pretty sure many of them have at least run into this at some point or another. The judges especially, again, they've pretty much all of them have at least seen something, whether it's filed by a lawyer or, a pro se party. This is going to be, frankly, more and more common. And unless we get to a point where the hallucinations are just so rare that, we actually can rely on these, I mean, it's going to be part of the practice is having to identify, hey, this opposing party, they submitted something that's completely false and it's just made up. And, then it'll be up to the court to figure out how to address that. But I certainly wouldn't want to be on the other side. All right. Well, thank you so much, everyone. I really appreciate you listening in and hearing me out for this presentation, especially on short notice and rearrangement here plans. If you have any questions, please feel free to reach out to us at the information provided there, the Florida Bar Ethics Hotline at 1-800-235-8619. Thank you so much.
Thank you so much, Jonathan, and thank you all for attending today's webinar. The course number for today's webinar is 9504. Again, the number is 9504. This webinar has been approved by the Florida Bar Continuing Legal Education Department for 1 hour general credit, 1 hour ethics, and 1 hour technology. Please self-report this course in the member portal. Again, the number is 9504. You will receive an email tomorrow via Zoom outlining this information. I also encourage Florida Bar members and Florida registered paralegals to take advantage of the Florida Lawyers Helpline, which is completely confidential and a free service which entitles you to 5 counseling sessions per year to help you develop strategies to overcome life's challenges, balance priorities, and better handle both personal and professional pressures. This concludes today's webinar. Thank you.